and the chamber. And in that process, also reviewed the legal documentations around renewal of mining leases. Though these engagements were informal, driven by our sense of urgency,
it was encouraging to witness the openness of the public officials to share their perspectives. However, we had hoped that the communications between the government and the company will be maintained, facilitating the company's exit I'll take that again. Though these engagements were informal and driven by our sense of urgency, it was encouraging to witness the openness of public officials to share their perspective,
and as well as the companies to engage with us on this important matter. We had hoped, however, that the
communication lines between the government and the company will be maintained for a little longer to explore a possible compromise. As a responsible policy think tank, ACEP has seen similar cases where public officials were convinced that their decisions were in the interest of the state, but were proven to be wrong. Consequently, those decisions have escalated into costly outcomes for the state. And I'll cite a few examples of that, and we have engaged you on multiple occasions on some of these matters. The attempted novation of the Ameri power plant, which possibly would have cost this country about $850 million. The Ajapa royalty transaction, which would have ceded Ghana's royalty stake to private interest, which today has raised over $1 billion, though we're looking for $500 million. The GMPC's attempted acquisition of Aker Energy assets for $1.65 billion, which turned out to be sold few years after for $1. We had to intervene to make sure those things did not happen. You also remember the recent forced attempted unitization of the ENI Springfield oil blocks, which went to arbitration and we lost. There are countless number of those situations that we have had to intervene as civil society. The advocacy on these matters gives us and our colleagues in civil society a solid track record of dispassionately analyzing government decisions, especially when they are made in haste, and we can see
continue to mourn for the losses to the state and the continued decline of investor confidence in the resource sector. We are therefore compelled and encourage an amicable resolution grounded in our laws and sound industry practices. Ghana has been bruised too often by hasty decisions, and we must remain vigilant. Information before us. We know that the state's decision, that's the decision of the government to take over the mines, that's our conclusion. The law is 703, as amended, states, and I'll quote expressly. Subsection 1 states that where a dispute arises between the holder of a mineral right and the Republic, all efforts shall be made through mutual dissolution or settlement. Subsection 5 also states that where a holder has notified the minister in writing that the holder wishes to refer a dispute for resolution, but for this subsection the terms of the mineral right would expire, the term shall continue without diminution for the period ending 30 days after the determination of the dispute. And I explained that. What this provision is saying is that when the company indicates its right to seek for redress in court, the government shall stay its action until that dispute is resolved before further actions could be taken. That is not what we are seeing. We understand that the company has formally notified the ability of the state to respect same. And under section 27.5, as I read, and accordingly, the mine's operations should remain undisturbed until the dispute is resolved. And now I want to go through some of the reasons that have been cited by government. And the public deserves a more rigorous and objective explanation from the government, because we don't see that. The suspension of active mining must comply with Regulation 22 of the Minerals and Mining General Regulations 2012, LI 2173. Subsection 1 reads, subject to Section 51 of the Act, where the holder of a mining lease proposes to suspend, discontinue mining operations, the holder shall, as at the time of discontinuance or suspension, and shall subject that plan to the commission in accordance with these regulations before the mining operations are discontinued or suspended. Resources indicated that the company had, however, they do not prove how processing stockpiles breaches the mining lease or the law, particularly when there are remedies in law for the suspension and discontinuation of a mining operations. Of the stockpile, the economics of the project may define when a particular grade is processed, and the relevance of the stockpile to the mine's output. The company has indicated that they communicated and obtained approval from the commission to process the stockpiles. The minister ought to verify this claim with the commission in alignment with provisions in the law before drawing conclusions. If the company's claim is true, operations as a basis for rejecting the renewal of the lease. If the claim is false, then the regulator, through its mining inspectorate, as a tool for punishment, cited by the minister. The minister says there was failure to declare mineral reserves. While there is no basis in law that not exploring for 2 years out of 30 years of operations is a basis of invalidating all the existing reserve data, feasibility studies, and submitted technical reports indicating mineable resources with an 8-year production outlook. These claims deserve independent verification rather than dismissal. No reserves in the mine, then it is confusing why the state is so eager to assume the risk of operating a mine that has no risk, an absence of a technical program. The company maintains that it submitted a technical program consistent with its previous renewals, because it has done previous renewals and the template is there. So it submitted the same renewal consistent with this previous renewals. This requires that the minister publishes the documents to clarify lack of budgetary allocation for exploration. That also is a matter in contention. The company has indicated that it continued to carry out exploration-related activities known to the commission and claims to have received. These two require. But ladies and gentlemen, most in mining licensing regulation states, and with sub-regulation 1, the mineral title department of the commission shall give notice accordingly to the applicant within 5 days after the review, and set out in Form 3 of the first schedule, and the applicant, in this case the company, shall correct the errors or provide the renewal application, and there are errors in that application. You are allowed 10 days to remedy those errors in the application. Process was followed before allowing a decision of this magnitude to proceed from the commission. Again, assuming government is right on this decision, it is also important to note that any mine closure must follow well-defined protocols. Assuming you want to even take over the mine, the company is required by and fulfillment of outstanding orders to have been overlooked in the haste to take over the operations of the company. Although the Commission's lease rejection letter stated that a forensic audit will begin within 14 days of notifying the company, it has been more than a month, and there is no indication that the audit has commenced. If this process is truly in the public interest, that is to audit the company to make sure that they have not cheated the state, why did the Commission renege on this important responsibility and proceeded to expropriate the mine? Such inconsistency must be addressed and require answers from government on them. But I also want to point out the most significant undercurrent on this whole development. Industry enthusiasts like us may be aware that in recent years, the company has been exploring options including a divestiture of the diamond mine, as it indicated in its 2024 report that if mineral reserve economic criteria mine, as is being interpreted. The conservative economic criteria is just a decision tool which operations of the mine. Economic decision if subject by saying that ACEP agrees that Ghana deserves to benefit fully with this national goal must be transparent and factual in demonstrating how their decision maximizes public benefits. Legal compliance. Already, the news portals have captured state officials, and also as implied in the minister's statement, that this is all an effort to nationalize the mine. If the policy direction of the government is to revisit the 1970s resource nationalization effort, which collapsed the mining industry until we revisited investment drives, we need clarity from the government on what will be different this time to leave no doubt in the minds of the investors, especially when the required actions per the law are clear, but actions of implementers differ. Ladies and gentlemen, when remedies are provided in the law, the hearts and minds of the implementers cannot be at variance with the prescribed remedies in the law. And we want government to note that. Tomorrow, an indication that tomorrow is not only Christ that will be crucified, but the mining industry risks, and pursue a legally guided resolution that protects the interests of both the states and the investors. I thank you for your attention.
Any questions, you raise your hand and then I'll come to you.
My name is Philip Anto. In your opening statement, you made mention of the government decision was.
Okay.
All right.
I'll take three and then you.
Thank you very much. My name is Kizito Kujo. I'm with the Business and Financial Times. I think if you revisit the minister during his vetting and subsequently looking at what has ensued, one is tempted to think that the agenda is to nationalize the mining space. Now, if so, would you say that they would require legislation, the appropriate legislation to do so, rather than this approach to...
Another question?
My name is Norvan. I want to nationalize the mine, but who stands to benefit as far as this move is concerned? I don't know the kind of preparations that we have done to ensure that the takeover, even if they have to do it, will be smooth. One that, because we are now hearing that the government is offering about 5% to the workers, just a way of trying to appease them, get them to, agree to the fact that, look, they want these investors to go away. And the second question is, we know also from the discussions in the media that there was supposed to be a forensic audit that the Minerals Commission was supposed to undertake. And if this has not been done, what's the effect? And is that what probably, caused the investor to also wait and see?
These questions, and then we'll come for another round.
Yeah, but can you clarify the last point again? Because I got the who stands to benefit from this and 5%.
No, so the forensic audit, what is the effect of not having done that? And could that also be the reason why the company lagged in taking any decision today?
Yes. So, the risk of judgment that we don't want to preempt the decision of a court, but we want government to follow the rules. And as I cited numerous examples of how we have intervened in the past, where government is way to go to court, they lost, and we are still paying billions, to us, to companies who won in court. So that possibility exists, but it's up to the court to really determine. And that's why we want the minister and the Minerals Commission to follow the law, what the law says. And it appears in this situation that it is the hearts and minds of the interpreters of the law that is in action, and not the law itself. And that is really problematic from where we're law to do that. It's something we can keep exploring. But of course, if government is saying that you want to take up a mine, does the government have a company that is qualified to mine? It's a legitimate question that we should be asking the government. The government doesn't own a mining company. You are taking over a mine, and you are not telling the good people of Ghana how you are going to produce from the mine. And also the inconsistencies of government saying that there are no reserves in the mine. If there are no reserves, why the rush to go and take it? So you are promising the workers no reserves to mine, and you agree that there are no reserves. Why are you expropriating it and again promising miners that you... So it means that you know there are reserves there. And there's actual data before the commission for them to examine whether truly there are reserves or not. Because before you grant a mining lease, and the various extensions that had been granted in the past, there are reserve data, year on year updated by the company. You can go back to that data and compare with the extracted resource to see whether the company has exhausted the reserve that they have declared over the years. There are no numbers to this kind of conversation, except the bully tactics to actually expropriate the mine. So that is why we are worried that the way we are going, if we are not careful, that could also turn out to be a problem for us going forward. The forensic audit is the commission itself that told the company when they rejected the application that they were sending auditors to come and audit them. If that action is in our interest, why have you not done it and you are sacking the company? So assuming you sack the company today and you realize later that they owe us 1 billion, where are you going to take it from? Because once you sack them from that field, the company can fold up. That subsidiary, even though Anglo Gold will continue operating here, if the subsidiary folds, Goldfields, sorry. If the subsidiary folds, where are you going to take the money from? Right? So we are not approaching this matter in accordance with the law, in accordance with the laid down regulations. And we want the commission to go wants to do. And sometimes under the cover of protecting public interest, are pregnant with individual and personal interest. And that's what we have seen in many of these transactions that we have dealt with. We have experience to detect when greed and corruption are at play. That we don't doubt that. And these are clear symptoms that when you cannot explain the position of the law on these matters, it is often corruption and greed that drives those decisions.
Okay, so our next round of questions. Are we okay? Yes, there's a hand up there.
Right, Ben. So I'm Patrick Bida. I work with the Herald. My question will require a simple yes in plain words that government is being lawless in this accusation. Thank you.
The regulations are twisted. You will not be far from saying yes. We are not clearly that even where there are errors, there are remedies in the law, but nobody wants to pay attention to the remedies. They are set in their minds and hearts that this is what we want to do, and we must achieve it at all. Sure that once gold is produced, the due interest of the state is protected. We get our share, and we must regulate to ensure that is not consistent.
Be granting any separate interviews after this. So if you have questions, please, now is the time to ask. If not, I'll ask Ben to give a summary of the entire statement in five minutes, and then we are out of here. We will not grant any interview here. If to your studios, fine, but not here. So if you have questions, please ask. Okay. So Ben, please, can you do a summary of all the things that
Right. So what we are trying to say here is that there are rules that govern the extraction of gold in Ghana, and companies are enjoying to respect and respond to those laws. In our mining agreements, it is stated unambiguously
That when a mine is due,
for renewal, the company is due for it. It's the operative word there is shall. The government shall renew the lease unless there are fundamental breaches that are also listed in the law, i.e. if they owe or there is an environmental disaster that they are not responding to. Those requirements are prescribed in law. They do not include reserve estimation. All right? They do not include some of the reasons that have been adduced by the minister to justify why they are expropriating the assets of the company. So we are cautioning that we should go back to the negotiation table and put the national interest above any other interest and make sure that the right things are done. That helps us to send the right signal to investors. If we are tired of the investors, let's tell them that we own the asset, we are tired of you. Give us our resources and go so that we can mine it ourselves. That is also an option. But let's not recalibrate and misinterpret the laws just to justify an agenda. It says that if you make an application, it clearly tells you that the agenda is in motion and you can't stop it. That cannot be in the interest of our country. So we are insisting that we should recalibrate the assumptions around national interest so that we are not misplacing it with any other interest in this particular instance. And that is what message we want to set out today. Unfortunately, this is the only day we have until the said expropriation happens, post tomorrow. So we need government to act now and act responsibly, not to endanger the collective interest of the people.
All right, thank you very much, Ben. The three people are asking if you can do a tree summary for them.
Where is
but
Charles?
you see, unfortunately, we are not too in a position to do that now. Hey, where's my phone? Is it here? All right. So, thank you very much for coming. Our communications team is going to, and then our admin team will also be on standby to handle the